They are always watching. They are always listening. They know your every move, every second, of every hour, of every day. They know your deepest and darkest secrets. The NSA. Now, to clarify, the National Security Agency, or NSA, is not a terrorist group, a super-secret cult, or a terrifying monster, but rather a government-funded agency dedicated to preserving the safety of America through the monitoring of domestic affairs. While this organization may seem innocent enough at first glance, the inner workings are quite intrusive and even unconstitutional. Through discussing what the Constitution provides in terms of personal privacy and the invasive and devious methods by which national security agencies try and protect American citizens, the right to privacy will evidently be proven not to be a threat to our national security. The Constitution is the most essential document for the rights of American citizens, but to be quite honest, this crucial writing can be difficult to understand and can be interpreted in many different ways. So what does this high and mighty Constitution say about our right and privileges as far as confidentiality goes? First, we should define privacy as stated in the Constitution. The word privacy is used in this legislation means the right to personal autonomy, or in simpler words, the right to choose whether or not to do or experience something, the right to be left alone. The Constitution, being the foundation of this great free nation, does grant this definition of privacy to every citizen. Sounds nice and clean-cut, right? Well, not exactly. The most often cited amendment for privacy is the 14th, specifically the Due Process Clause. This clause states, quote, "No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property, nor deny any person within its jurisdiction the equal protection of the laws." End quote. This is a long way of saying that every citizen has equal rights to privacy of personal life, and that those choices cannot be discriminated against federally. But what gets sticky is what counts as infringement on privacy, as seen in the landmark 2003 Lawrence v. Texas case. The basis of this case was that a man named John Lawrence had been having sex with a man named Tyrone Garner while same-sex intercourse was still illegal in Texas. After being charged and convicted, a series of complex legal maneuvers put Lawrence as the spark of a groundbreaking Supreme Court case to legalize LGBTQ sexual activity on the basis of the 14th Amendment. The ruling of this case in favor of Lawrence showed exactly how the constitutional right to privacy protects everybody, but also it showed how this right can be interpreted in many different ways, as argued by the opposition. One of the judges, Justice Anthony Kennedy, later explained the ruling in that, quote, "The petitioners are entitled to respect for their private lives," end quote, and that Mr. Lawrence's, quote, "right to liberty under the Due Process Clause gives him the full right to engage in his conduct without intervention of the government," end quote. The Due Process Clause is what won this historic case, and is what supports personal privacy for all people. Now that privacy is better defined, let's take a look at how this constitutional right is undermined in the current invasive system parading in a facade of national security. The most famous and controversial facet of the national security versus privacy debate stems from the Patriot Act. This legislation was created in 2001 by President Bush after the 9/11 attacks, with the intention of stopping future terrorist attacks and activities by the monitoring of certain records. Seems fine on the surface, but if one should peek behind the curtain, a huge mess unfolds. This mess is known as Section 215, which grants the government the right to require businesses to hand over any books, records, files, or other tangible thing at their request. Section 215 is so incredibly broad that it really could be justified for the commandeering of any information that the government has a whimsy for. This brings us back to the good old NSA, who's intentionally set vague limitations on this section to allow for the most invasion of privacy they could make legal. Not only tangible records were included in this section, but also the surveillance of phone calls were covered. Under this particular law, the NSA could legally record the endurance of phone calls and who they were being made to. For everybody, not just suspected terrorists. This is a blatant violation of the 14th Amendment because there's no reason at all to be recording countless civilian phone calls. This totalitarian style of surveillance was perfectly legal, but if one recalls a certain whistleblower from 2013, the tendrils of government scrutinization runs much deeper than what the law permits. Edward Snowden, a former member of the CIA, released countless documents disclosing the unscrupulous methods of monitoring routinely practiced by the NSA. For example, Snowden showed that the NSA did record the content of phone calls, not just the direction and duration as claimed. He also proved that the National Security Agency could look through private Google accounts, video chats, web searches, emails, and much more. Edward Snowden essentially exposed that the NSA systematically, illegally, and unconstitutionally monitored regular civilians. No matter one's position on the man himself, the information he gave needs to be used to demand our constitutional rights that have been underhandedly denied for too long. Now, not everyone feels that the government monitoring everyone's activity is so horrible. National security has a high price, and many people are willing to sacrifice their right to privacy for it. While this wouldn't be such an unfair trade-off in theory, the problem is that programs like the NSA, meant to catch terrorists, really don't work and are ill-filtered. To go back to the Patriot Act, to actually monitor somebody's phone records, the NSA has to get their surveillance approved by the FISA courts. Again, not a bad idea on the drawing board, but ineffective. Out of the 35,432 requests for surveillance the courts received from 1980 to 2015, it only rejected, get this, 12. What is the use of a court that only rules one way? Furthermore, in the surveillance with the provisions provided by Section 215, the NSA has only been able to stop one terrorist plan, which consisted of a cab driver sending $8,500 to Al-Qaeda. The need for national security is vitally important, but stripping American citizens of their given right is not the way to do so from a moral nor a practical standpoint. Every person wants to be secure in their own country, but the sacrificing of constitutional privileges is unnecessary and just wrong due to the unconstitutionality and glaring deficiencies of the current security systems. After hearing about all the ways in which the safety-driven bureaucracy has failed, one would be inclined to give up hope, but don't. The only way to fix this systematic problem is through the government itself. Remember Section 215 in the Patriot Act? Due to the collective voicing of concerns from American citizens, the act was not repassed last year. Fighting bipartisanly around a common issue that affects everybody is the only way that we can change the system and fight for the rights we deserve. We, as American citizens, deserve the right to exercise and revel in our freedom. We deserve the right not to be constantly scrutinized by Big Brother, and we deserve the right to privacy.